In this episode of No Holds Barred, we're going to talk about stand your ground. And we're going to talk about self-defense in California and in many other states where the law is very similar or the same. Stand your ground. We've heard for years that it's some kind of right-wing law that happened in Florida back in the 90s to suppress whatever. In the state of California, we have probably the strongest stand your ground rules of any state. And I want to say it goes all the way back to People versus Hatchett, a 1942 case in California, a Court of Appeal case. It was an interesting case in which there was a fight in a house. A woman, Ms. Hatchett, got a gun. Somebody else in the house had a gun. And she tried to get out the back door, and the back door concerned her. She didn't think she could get out, so she turned around. She stood her ground, and she shot and killed a man that was approaching her with an iron from the fireplace. She shot and killed him. Her lawyer asked for an instruction that she needn't flee, that she could stand her ground and shoot, and the judge refused to give that instruction. After she was convicted, the Court of Appeals said, time out. She absolutely had a right to stand her ground and defend herself. So the stand your ground rules in California go way back, and it makes sense. It clearly makes sense. So neither left nor right, neither conservative nor progressive, we are a nation of laws and of rules, and most of them have a good foundation, and our stand your ground rules have a good foundation. Let me go and talk a little bit about a couple of kinds of cases, and we have retreat states and no retreat states. People say, well, what does that mean? In a no retreat state, you, under the rules, you do not have to retreat in the face of danger. Most states in the United States are no retreat states. Some, and most not, but more recently, all are pretty much no retreat states. We have the retreat state. And that rule is, or was, if you could more easily escape the danger, run out the back door, you had an obligation to do that. But it's much tougher, and you could picture, well, wait a minute, can I get away? Do I have time? And somebody looking at it objectively, well, they actually had time to run out the door. Yeah, but I was afraid I was going to be shot in the back. So you could see why no retreat. If you were in a position where you reasonably believe you're going to suffer death or great bodily injury, you don't have to retreat. California has a jury instruction, and I have it here, under CalCrim 505. But under CalJIC, when I was a prosecutor, the same instruction, it's just the language is a little more understandable nowadays. And the language is essentially, faced with the possibility of death or great bodily injury, you may stand your ground, and you may pursue your assailant until you believe you are in a position of safety. Now, when I tried cases, I tried 17 murder cases as a prosecutor. I lost 2. In both cases, self-defense was claimed. I want to say, a judge has a sua sponte. He has an obligation, if the evidence presents itself, even if the defense does not ask for it, to give an instruction on self-defense. The new law, CalCrim, the new jury instruction, is essentially the same as the old, and it contains that same instruction about standing your ground. I was kind of interested during the Trayvon Martin and the George Zimmerman case in Florida, which was not a stand your ground case. It was a self-defense case. But it was a stand your ground case because that was the law in Florida, and people talked about stand your ground. And all of these talking heads in California and all over talking about how bad this new rule of stand your ground was, how Florida, and I sent off copies of the jury instructions in the state of California to a number of people, local people, Ron Owens at a local radio station, all of them saying, wait a minute, We had celebrities in Hollywood that said, I will never go to Florida and perform ever again because they have that stand your ground law. And I didn't want to send off to them, but I wanted the press to say, here is what we have, a stand your ground rule, and it's a good rule. We would expect. Let me talk about an example. I think of Miss Hatchett and her situation of being confronted with somebody that clearly wanted to kill her. Think of the castle doctrine that we often think about. And I remember talking with a policeman not too long ago who was kind of remarking, yes, if you shoot somebody in your front yard, you better drag him into your house. And he was talking about the castle doctrine. No, you don't have to drag him into your house. As a matter of fact, wherever you are, if you objectively and reasonably believe that you're going to suffer death or great bodily injury, or you believe that another is going to suffer death or great bodily injury, you have a right to use all reasonable force necessary. Now, the law is interesting about that. All reasonable force necessary. So, if somebody is in a fight and they're using a dishpan to whack their friend, and their friend typically, unless they believe they're going to suffer death or great bodily injury, doesn't have a right to shoot and kill them. So it's reasonable force necessarily under the circumstances. So we have a recent case in a state where somebody was being beaten with a skateboard, and people were stomping on him, and he used a gun to defend himself, and he killed one of those people that was beating on him. And the jury in that case found self-defense. And I would argue that it was proper self-defense. Never mind left or right, never mind what the media says. As a nation of laws, as a state of laws, as rules, it's a good rule, and it was appropriate under the circumstances for that individual to use that amount of force to protect himself. And too often we look at it as to what's the person's politics, where were they, why were they here. Well, let's talk a little bit about self-defense and what's not self-defense. If you take a gun and you see somebody breaking into your neighbor's house and you want to be an officious intermeddler, and instead of calling the police you decide, I'm just going to go over with my gun. Hey, buddy, you can't break into the house. And the guy goes, screw you, I'm going to break in. You don't get to shoot and kill him. You don't get to. You don't have a right of self-defense. You don't get to reasonably believe that you're going to suffer death or great bodily injury. And we see this oftentimes in cases where people raise self-defense, but really it's not self-defense. I had a case in which somebody got in an argument in a bar, and he was arguing with a really big guy who had just gotten out of prison, a scary guy. And he said certain things to the big fella to lure him out of the bar, knowing that he had a gun in his car. And he ran across the street to his car, and he pulled out the gun behind the door, and he begged the big guy, come on, I'll show you what I got. And the big guy walked across the street, and I argued he shook the red flag in front of the bull, and the bull reacted to it, and he shot and killed him. And I argued that was not self-defense. He lured him out for the purpose of killing him. However, the law of self-defense in the state of California is once a claim of self-defense is made, the prosecution, the people of the state, have the burden to show beyond a reasonable doubt that it is not self-defense. And that's a very heavy burden. So the people have the burden of proving that the person committed a crime, and they have the extra burden, if self-defense is raised, of saying it's not self-defense beyond a reasonable doubt. That's a very, very tough burden. If there's any evidence that shows it could very well have been self-defense. Another self-defense case that I had is a woman shot her husband in the back as he was going out the door. And turned out he had a checkered history. he drank a lot, and all of that came in, should not have. All of that came in, but at any rate, the jury decided that he was a bad guy, and they decided that it was, in fact, a self-defense case. Proving that it was not beyond a reasonable doubt was difficult. So those kinds of things, but I want you to understand the rules of self-defense and stand your ground in today's world are good rules. You certainly would agree that if somebody has a reasonable right of self-defense, they should be able to defend themselves and to pursue their assailant. People ask me, well, what do you mean pursue their assailant? And I say, well, let's say with your family at a park and you're picnicking and some crazy guy's running around hacking people with a machete, and you retreat back. You have a weapon. You don't pursue him, but he stops at a table and he's huffing and puffing, and you appreciate the fact that as soon as he gets his breath back, he's gonna start again. So you pursue him until you are in a position of safety and the others around you that you reasonably believe are going to suffer death or great bodily injury. So that might be kind of simple, but that is the idea, that you can actually pursue your assailant. And those are California jury instructions. And let me talk a little bit about that. The People versus Hatchet case of 1942 is not the legislature passing some rule. It is case law, stare decisis. And what that means is the court has looked at the law, and the law is made by the cases rather than the legislature. That concept of stare decisis, so what I want to say, people get upset about a legislature passing some rules that people disagree with, or we have a proposition in California that nobody read the fine print, and all of a sudden we realize, oh, wait a minute, we didn't realize that all those crimes were kind of get out of jail free. That's not what our stand your ground, nor is it our self-defense rules. Those are rules based on actual case, facts, and rulings of the court, which have gone up to the Court of Appeal and on up to the Supreme Court, and those case law cases that can be cited. And People versus Hatchet, 1942, can be cited for a stand your ground. I often tell people, you want to really know what factors constitute certain crimes, you can go to the penal code and you can look at it. As a prosecutor, what we did was not only look at the penal code, we looked at jury instructions. What are jury instructions? That's the instructions in the law that a jury is going to get in a case. That's the place to go. So if you're really interested in wanting to know what is a first-degree burglary and what does the prosecution have to prove, go to the jury instructions. So I would tell you, if you really want to look at the law of self-defense in the state of California, what a jury listens to. They don't listen to the press. They don't listen to the legislature. They listen to the judge giving them jury instructions. Look at CalCrim, California Criminal Jury Instruction 505. It will describe self-defense to you, reasonable use of force, what is reasonably objective for that person, and the stand your ground language is in that instruction. And you can Google it, go right to it, look at CalCrim 505 and read it. So that jurors, in doing their jobs, are supposed to listen to the facts and decide the facts based only on the evidence that comes in the case, and put that together with the law that the judge gives them. And that law constitutes the jury instructions. And there are many jury instructions. And typically the jury gets those jury instructions during the course of their deliberations. They can go back over them and look at them. If they have a question, they can go back into court and ask the judge to give some clarification as to that. But that should be what the case is decided on, the facts of the case from the evidence only and the instructions. And too often, we as citizens say, well, that wasn't a just result because we don't like the result. We don't like the defendant, or we don't like the victim in this case, and this should be the result. No, we have a very good system of laws, and in general, we don't get aberrant verdicts, in general. And we can all look back and say the woman who spilled her hot McDonald's coffee in her lap and got X number of millions, which unbeknownst to most people was reduced way down over time at the appellate level. Or somebody who walks out the door in a self-defense case, we don't like it because we don't like them. Or perhaps we don't like how the press has framed them or the situation that they were in. But the jury doing the right thing and looking at it and saying, no, this is the law and this is the evidence, and the facts from that evidence reaches this result. I'll give you a little example. Back in the day when I was a prosecutor, I tried a case involving a wallet gun. What's a wallet gun? Well, there was a fellow who was, for a lot of reasons, arrested, none of which mattered at the time of trial because they were all reduced down to this one case of illegal possession of a wallet gun, which was a misdemeanor. And he had it at his business. And when a search warrant took place at his business and he was asked by the officers, have any weapons or anything? He says, yes. He pulled a shotgun out and put it on the table. And yes, I have this. And he pulled out a wallet gun. So picture a wallet. And it has a little hole in it. And inside fit a .25 caliber one-shot gun. And you could pull that out and you could pull the trigger. The interesting thing about it, you can buy the wallet legally, you could buy the gun legally. And put the two together, and guess what? It's a misdemeanor. I tried that case. I was a young DA, and I tried that case. And I tried it during voir dire. And I said to the jury, ladies and gentlemen of the jury, you may not like certain laws that we have. You may not even like the laws in this particular case that you're going to hear at the end of the case from the judge, the instructions. But it's not your job to change the law in the jury room. That's for the legislature. So I want you to rely on the law that the judge gives you together with the facts of this case. The jury found the man guilty of possession of a wallet gun. And after that, they looked at the judge and they said, we want to talk with you, Your Honor, about this case. And we don't want him here, meaning the prosecutors. And their complaint was they didn't like the law. They didn't like it. We've heard a thing called jury nullification. Interesting. It's a concept of the jury not following the law, saying we don't like the law and we're going to nullify the law in the jury room. And that's improper, but it happens, and we know politically or somebody, I just don't like that law, and we don't think it would be justice if we followed the law, so we're going to nullify the law. We're going to do something different. And that's a concept that we see sometimes, more and more in our world where you can go online and Google everything in the world, and you have the press or social media saying, this is what you should do, or this is outrageous, or that's outrageous. Very difficult many times for very serious cases to try the cases because the jury already has seen and heard so much and been pulled so many directions. A funny thing is, during the O.J. Simpson case, many of the jurors were asked about who O.J. Simpson was, and we don't know who O.J. Simpson is. Well, that's a good jury if you can find it. But for the most part, jurors can be tainted by press issues, by the media, by people prejudging. That's why it's so critically important for people in positions of power who are elected to uphold the law should not make statements about cases until after the case is resolved. And that's something that we see oftentimes. So there you have it. We could talk a lot more about stand your ground or self-defense. I wanted you to hear basically about California law and where it stands. And that concludes this discussion of stand your ground and self-defense. Stay tuned for our next episode of No Holds Barred.